Start now. Assalamu alaikum. Thank you so much for joining us in the fourth session, the final session of the series in English. Just a reminder that there will be a series of the same information presented to the community in Arabic, in Urdu, and in Somali. Those sessions are provided through the Muslim Legal Support Center, partnership with us, the Coalition of Muslim Women, as a public education about different topics within the family law. Our lawyer, Lina Shakir, is providing her time and information in these sessions, and we thank you very much for that. Before we start, I just need to notice that the primary audience for these sessions are Muslims, although the information provided will be helpful for racialized community as well. We understand that this information will be helpful for the service providers. We welcome that, and we're happy to facilitate this knowledge transfer. The only caution we would put forth on this aspect is that the primary audience has lived experience. The lived experience, which is kind of like a background on these issues. For the service providers and others who don't have the lived experience, we urge you to seek more knowledge to understand the complexity in this issue. We say this because we are concerned that without this holistic context, there may be some unintentional harm on those who are served. CMW has training and programs that provide that deeper context. Please contact me, Wissam Osman, for more information about these trainings. And sorry, I didn't introduce myself. I'm Wissam Osman, coordinator of Toward Violence Free Homes, a program of Coalition of Muslim Women. I'll stop here, and please, Lina, start in your presentation.
Thank you, Wissam. So as she said, today's the final session. We're going to be talking about child rights and child protection. So as always, this is just a lot of legal information. It's not legal advice. The intention of providing legal information is so that you can pursue actual legal advice that's customized to your specific scenario and know what issues you want to address with a family lawyer. So I'm going to introduce a lot of new terms to you today, especially relevant for the topic that we're addressing today, because there's a lot of new legislation that has actually changed a lot of the words that we're used to talking about, such as custody and access. Those are no longer words that are effective, and they're both provincially and federally, those have changed. So there's going to be a lot of terminology thrown at you today, but the idea is to help you understand the changes that are being made, so that you can now go to a family lawyer and accurately identify what issues you have.
So those changes has been in comments today.
So we're gonna go through them, and they've been effective. I believe the Divorce Act has been effective since March, in Ontario more recently, and so they align together.
Okay, so since March there are new set of rules. That's what it is, right?
There's new terminologies.
Okay, terminologies. Okay.
Yeah. So a lot of the rules are similar. Some of them have changed, so we'll go through them. So first, we're going to be talking about child rights. So what used to be called custody now is called decision-making responsibility. And we'll also be talking about what used to be called access is now called parenting time or contact orders, depending on whether you're the parent or somebody else, such as a grandparent. We'll also touch on what happens when somebody takes a child abroad and tries to kidnap them, as you will. And then we'll talk about child protection. So what's the role of Children's Aid Society? What can they do? What can they not do? And what should you do when your child is removed from your care? And how to complain appropriately about any misconduct that you feel is taking place with your interaction with the Children's Aid Society. So first, we're just going to give a brief recap about what laws govern when we're talking about the relationship between a parent and a child. So we spoke about before how you might have contractual agreements, such as a separation agreement, and there you might have agreed with your spouse or partner what to do with, let's say, how you want to divide your parenting time or access and visitation rights. As always, as we're going to see throughout the rest of the lecture today, everything is subject to what is in the best interest of the child. And something to keep in mind today is that these rights are actually the child's rights. They're not the parent's rights. So we're going to really be reinforcing that today. So in the federal law, if you are getting divorced under the Divorce Act, there are a lot of ancillary rights that you can apply for and seek. The decision-making responsibility, parenting time being two of those rights. And then with the provincial law, as we spoke of previously, those ancillary rights that are only applicable to married couples in the Divorce Act, because you can only get divorced if you're married, are frequently provided in other provincial legislation. So the relevant provincial legislation in today's discussion point is the Children's Law Reform Act. So typically, either unmarried Ontario residents can use this. So if you are unmarried, but you maybe are a common law partner, you have a child, and then you're separating, right? Or if they're married couples who are separating, but they just don't have the time to go through an actual divorce yet, they can also proceed under the provincial law. So as I said earlier, both federal and provincial legislation have now aligned and they've introduced these really important terms. So custody is now called decision-making responsibility, and access changed to parenting time for parents and contact for non-parents. A big reason for this is because of the amount of confusion that was taking place between what does custody mean. Now the definition of it is basically in the name or the title of it. And with same thing with access. Another reason is it's supposed to promote less win or lose feeling because it's no longer the case that you have a custodial parent and an access parent. The overlap of these responsibilities and parenting is much greater as we're going to see. So regardless of the legislation being used, whether you are being divorced under the Divorce Act, the federal law, or whether you are proceeding under the Ontario's provincial law, and every province has something similar. For us, it's the Children's Law Reform Act, the CLRA. The determinations about how children spend their time with each parent, as well as what decisions are to be made about those children, are always subject to the best interest of the child test. So what is the best interest of the child? There's a long list of factors. These are just some of them. And under both the federal legislation and provincial legislation, there are a list of factors. We're going to go briefly through some of them, but the key point to keep in mind is that it's not a checklist, right? Because while the court does have to consider all of them, a judge can say that one is more relevant and give a lot more weight to one factor over the other. So it's not a strict mathematical formula. Sometimes the factors, if it's a very young child, it's going to, their needs and their best interests are going to vary from somebody who might be from a specific community. And some of these factors are more relevant to, for example, children who have extended families versus a very nuclear family. So some of the factors that are laid out in legislation is the emotional ties between the child and the claimant. The claimant would be the person who is seeking for either the parenting time or the decision-making responsibility. The views and preferences of the child. I remember a lot of people had some questions about this in the past. Yes, it is a consideration, especially the older they get, the more they are able to express themselves. And we'll also touch on specific ages to come. However, essentially the more they're able to express themselves, and even if they're unable to express themselves, they can have a child lawyer appointed to them from the Office of the Children's Lawyer. Their views and preferences will be taken into consideration, but it's not the be all and end all. They are not the decision makers, right? The judges at the end of the day. How long the child has lived in a stable home. So if the child has been in and out of different homes, it might not be in the best interest to continue residing with a parent who does not have a stable place of residence to provide for that child. How able and willing each parent is to provide the child with the guidance and the education necessities of life, and to address the special needs of the child. This is also relevant if children are disabled or have other types of special needs, and one parent maybe has more capability to specifically cater to their needs. Maybe they have more flexibility with their time off so that they can attend to them. Maybe it's their ability to speak sign language and the other parent can't, right? There's a lot of unique circumstances, and the point of this test is to be able to equip a judge to specifically address what is best in your specific case, but it's a very flexible test. So any proposed plans for care and upbringing, how permanent and stable the proposed family unit is. So it's not about the stability only of the residents, but it's also of the members of the family. Whether that person can take on the roles and responsibilities of parenting, or whether they are consumed with other activities, and the familial relationship between the child and each person. So as I said, there are some slight differences between provincial and federal legislation. That's something that you should talk to your family lawyer about. The point of the recent amendments that were made was to closely align the provincial and federal legislation together. So, however, because it's very new, and because it hasn't been very frequently interpreted, it's kind of unclear to say if they align exactly 100% identically. However, that's the goal, and the reason in which a lot of these changes came about was to more closely mirror and align the rules under provincial and federal rules. So we're going to go into each of the two rights that we described. So decision-making responsibility. As I said, so it was formerly known as custody, and what custody or decision-making responsibility means is that this parent has the authority to make those decisions about how to care for and raise the children. So after separation, the children may no longer be with one's parent, but that parent may still have authority over that child's religion or spirituality or education or healthcare. Those are really the major decisions. Others include really important extracurricular activities. It depends on the specific child at hand, but those are the main ones there. What is it not? Decision-making responsibility is not about which parent the child lives with or how much time a child spends with, right? So even if only one parent has decision-making responsibility, and we're going to talk about the types of them later, so it is possible that both have it, right? But in this scenario, even if only one parent has the authority to make those types of decisions about healthcare and religion and education, it's possible that the child may be spending equal time living with both parents, right? So they might live in one place and be listening to the orders of, their other parent. The opposite's also true. So the child might live mainly with one parent, but both parents share the decision-making. And non-parents, so grandparents, for example, can also apply for decision-making responsibility. So what are the types? there's lots of different types. So a sole decision-making responsibility is when only one parent cares for and makes all of the decisions about their children's care, education, religious instruction on their own. So the other parent may or may not have parenting time with the kids. It's not directly or inversely correlated. They're decided separately. And then joint decision responsibility is when both the parents make decisions about the child together. So they might be communicating with each other in order to come to a consensual decision, or they can split up the areas of responsibility, which might be more practical. So one parent might decide that they're going to make any decisions about health, and the other parent has the decisions about religion, for example. And then split decision making responsibility. If in the scenario where, let's say, the parents have multiple children, they might say that they have authority to decide all of the different decisions that come with one child, and then the other parent has the authority to make decisions over the other children. So you're not splitting the question or the type of responsibility. You're now splitting the actual individual, right? So which child are you responsible for, not what topic area are you responsible for. And then the second type of child right is parenting time and contact orders, right? So parenting time is if formerly it was just known as access. Both of them were both known as access. Parenting time was accessed by a parent, and contact orders were accessed by non-parents. So typically grandparents or other guardians. The key point to keep in mind here is in the past, parenting time used to be called access for the parent who didn't have any decision-making responsibility. That has changed, and now all parents usually have parenting time. And why? It's because it's usually in most cases, it's usually in the best interest for the child to spend time with each parent. So both parents are usually eligible for getting parenting time, but it's really about what is in the best interest for that child, right? Again, it's not the parent's right, it's the child's right to see the parent. It's not the parent's right to see the child. So with parenting time also comes the right to get information. So it's not only how much time you're spending with your children, right? It's also your ability to get information from your other ex-spouse, right? Or institutions, maybe it's the school or the hospital, on your child's health, education, and well-being. The other thing to keep in mind about parenting time is that it's not necessarily the time that they're actually spending with the parent. So for example, if your child is at school, however, they're still under your care, that is considered parenting time as well. And one other point to keep in mind, and it's a frequently asked question, is how does it relate to child support? Those things are calculated in two separate ways, right? So the right to child support and the right to parenting time are two separate rights, and they're both rights of the child. So a parent cannot be denied any parenting time just because they didn't pay child support, right? So you can't penalize me for not paying my child support by refusing me to see my child. And that's because it's not my right to see my child, it's the child's right to see me, right? So you're not harming me, or you're not trying to modify or correct my behavior by telling me that I'm now can't see my child when I'm not paying child support. You're actually harming the child when you're preventing people from seeing their parents. So a parent still has to pay child support even if they do not have parenting time, right? So they are just calculated in two separate ways. So what are some of the types of parenting times? These are some more terminologies for you. So if there's very cooperative parents, you can just keep it very informal. And this doesn't even have to be necessarily something that is written down, but it's preferable, and there are apps for this now to help and communicate in a very friendly way that's documented, and those apps are pretty well recognized. So if you believe that, you know, there's going to be a lot of changing situations, maybe a move is coming up, and you know that you are able to work collaboratively and in a positive way, and it has been worked. This doesn't always work, because sometimes there's just issues of domestic violence. There's issues of just uncooperative natures between parents. But if it does work, it can be very fruitful, and you can just informally make open and flexible plans to change situations, and you can just adapt what is necessary. You can also have fixed parenting time. So this is where you might say, you know, every other weekend, the child will be with so-and-so, and then the rest of the other weekends are with me, right? So you can actually have a detailed schedule, and it will cover what religious holidays are they going to be, or where are they going to be on religious holidays? What about the long weekends and the birthdays? You can even specify conditions in it. So it's not only about specifying the time and the days, but you can specify, you know, who's going to pick up or drop off the child, and where the child is going to be spending that long weekend. So maybe it's going to be at a camp or something. Then there's also shared parenting time. So this is where parents share the time spent with the child, and the child spends at least 40% of the time with each parent. So it doesn't have to be necessarily 50-50, but it's roughly around there. And split parenting time, similar to how we discussed previously when it was with decision-making responsibility. Over here, if the parents have more than one child, each parent can have at least one child living with them most of the time. So again, this is where you're not dividing the time, but here you're dividing the children, and saying that maybe dad will take the son and maybe mom will take the daughter. Then there's also a very frequently utilized type of parenting time, and that's a supervised parenting time. So in addition to the orders of whether it's flexible or strict in terms of scheduling, you can layer another categorization of whether it's supervised or not supervised. And so typically supervised is there when there may be history of, you know, drug abuse or alcoholism, but also sometimes there's just, you know, temper management issues that take place where it might be in the best interest of the child to meet with a parent in a public setting, or just in the presence of one other person. That can even be triggered because of cases of domestic violence, right? So if one spouse has been violent towards the other spouse, one parent may very rightly so feel threatened and feel that her child may not be safe when visiting her ex, right? So this is one of the common reasons that there are supervised parenting time facilities. So it's, like I said, it doesn't have to be in the complete public. Sometimes it just is a friend or a relative that the two parents can agree on. It can be a paid professional though, such as a social worker. And frequently there are these supervised access centers. They are funded by the ministry, and children's aid societies can direct you to them, or sometimes they have their own ability to accommodate, and they'll have a social worker come and attend parenting time. To be so that they are the ones who are supervising. Just as we mentioned before, so if with respect to international custody, so this has this is one of the frequently asked questions. So if a father takes his minor children to a Muslim majority home country without the mother's knowledge, what to do, right? So it is difficult, but it's not entirely possible to use that country's legal system to regain custody over the children. Technically, Canada is a signatory to the Hague Convention on the Civil Aspects of International Child Abduction, and that's essentially a treaty. It's the only treaty that exists where these countries are signing on to an agreement that has to do with custody, and it's specifically dealing with cross-border abduction. So there is a legal tool that you can use through Canadian law, through the Hague Convention, technically international law, and a lawyer would be able to help you to do that. It's not always the most easy route to do it, but it is there. So maybe before we move on to the second group of, or second half of presentation, we can just pause to make sure if there are any questions.
I have a quick question.
Sure.
This is regarding the children custody, and once the child is under custody of a non-Muslim parents, like foster parents, so that could be changed later on from parents to send a request?
Yeah, that can be changed, right? It's always going to be what's in the best interest of the child. So if that child has been with, let's say, that non-Muslim family for a long period of time, it becomes harder and harder to prove that it is in their best interest to now be moved again, right? Stability with children is one of the factors that determines what is in the best interest. So typically, it's probably recommended, and a judge would probably find it in the best interest for the child to obviously be in the community that they are raised with, but depending on their age, how long or when, at what point they were moved into that foster care, which we're going to talk about in the second half, which deals with the foster care system. There's a lot of factors that can influence, right, whether that child is better suited to be with a Muslim family. Maybe maybe they were removed when they were like 16 years old, and maybe that is something that they really want to come back to. So there's a lot of different factors that can influence it. But it's really what's in the best interest of the child.
Thank you very much.
Yeah, you're welcome.
We have a question in the chat.
Yeah. The question is there anything that can be done if a parent brings a minor child into Canada and separates them from the other parents under Canadian law? Or does it depend on the laws of the country where the minor child immigrated to Canada from?
Right. So if that country is a signatory to the Hague Convention's treaty, then that would be the mechanism or the tool or vehicle of unseparating the child, right? So if they are not, then that's when the problem comes. So it's not about whether it's the laws of the country, it's really about whether the country is a signatory to the treaty. So I'll move back to, you can probably just Google the Hague Convention on the Civil Aspects of International Child Abduction, and you should be able to find all the different countries that are signatories onto there to see that. You're very welcome. Okay. So
I have a question, sorry, Lina. The question is, in a case of domestic violence issue, or doesn't have to be physical abuse, it could be any other kind of abuse. If the mother, for example, decided to leave the house, does she has a right to take her kids with her? Or if she took them, the husband can sue her that she abducted the kids or something like that?
So the the parental abduction I was talking about under the treaty, was specific to abducting them across countries, right? So if the question is only domestically,
Yes.
then that's not really, that's actually referred to as parental alienation, right? And that's basically where it's domestic abduction in a way, and the parent is going to try and alienate the kid from the other parent. Now, it is a problem. It does happen a lot, of course. And what ends up happening is that the other parent would, of course, try and bring an action before the family court to try and reclaim it. However, depending on how long the child has been with, let's say, the mother, and it will be difficult again for the husband or the alleged domestic violent person to regain authority over the children, because it's been such a long time. But the more important fact that's you've shared in the scenario is that it's a woman facing domestic violence, and so that is definitely a factor that is considered when the best interest of the child is considered. Because as we're going to see in a second, one of the things that courts always look at to see whether a child is even in need of protection or not is just whether they've witnessed that type of violence between their parents. So very frequently, a court will say that, you know, it's not in the child's best interest to be in one place or the other, just because they will see violence if they are in one place or the other, even if it's that violence isn't necessarily directed to them, right? So the domestic violence is definitely something that is a big factor. I don't think it is ever a good idea to just take children and run away. Obviously, if you are in an emergency situation, then that's what you would have to do. However, if somebody who's facing domestic violence is able to speak to a lawyer to try and do it, you know, get her papers straight and get custody, or now it's care over her children in a way without alienating the kids, I think that's probably what's would be my best advice.
Okay, thank you.
Mm-hmm. You're welcome.
If
We have some
one
questions.
spouse, yeah, what if spouse is like delivering from the state, stops seeing the father to her daughter, is just 18 years old. Happen in that substance, like her wife is sitting continuously from the state to the daughter, just to see the father, because she doesn't have any.
Sorry, your voice is really cutting up. I'm not hearing the question.
Yeah, try to write down in the chat. Maybe it will be better.
Okay.
Yeah. In the meantime, there is a question in the chat. If
Yeah,
there is a
I'm writing over here. Can you hear me now?
Yes.
Yeah, I'm saying that what if one spouse is providing false statements to the authorities just to stop seeing the daughter to her father, and the daughter is about 18 months old. So because the wife is continuously providing false statements to the authorities and stop seeing the father to her daughter, what happens in that scenario?
Yeah. An 18-month-old is a pretty young age. So sometimes that is an age at which it's possible that a judge would say it's in the best interest to be with the mother, because the mother may be able to better provide for a child that young. However, it's the situation that you're describing of intentional alienation is obviously something, a practice that should be avoided, and it's something that although won't penalize the child, because it is the child's right and what's in their best interest. So we don't punish the parent for their bad actions by moving the child around, right? That's not what the judge is going to do. The judge, even if the parent may have done something wrong, they're always going to say, putting aside whether we should encourage or deter the parent's actions, we're going to put that aside and we're going to think about what is best for the child and where should they be.
Gotcha. Thank you so much.
No problem. So with respect to Children's Aid Society, so we're moving on from child's rights of seeing their parents and child rights of knowing who's going to have decision-making responsibilities to them being protected by somebody other than the parent, right? So a lot of people know of CASs, the Children's Aid Societies. There are 50 of them across Ontario. There are 12 Aboriginal or Indigenous, 2 Catholic, and 1 Jewish. Each agency operates independently. And the job of each one is to investigate when they hear that a child may be in need of protection, and then decide whether or not that child is in need of protection or not. So they'll usually look into and investigate into reports of children under 18 years. So if Children's Aid Society is informed by somebody that this child is being hit or is being tied up or is being punished in a way that is very extreme, such as not being permitted to eat by their parents, or if they're being harassed and sexually, or if they're even left without supervision. Those are some of the things that might, especially if they add up together, they might lead a Children's Aid Society to check in on a family. So who's in need of protection, right? So the mandates of the Children's Aid Societies are to see if a child needs protection. And if they decide that they do, then they have certain powers and actions that they are supposed to take. But how do you define who needs protection? So there's 2 big words here, and that's neglect and abuse. So if the child is left alone, uncared for, or neglected, and now that's either at risk of being neglected or is actually neglected, right? So if the child is at risk, or potentially there's information that leads the Children's Aid Society to say that this child is likely going to be abandoned in a way, if they're going to be not provided for or harmed in any way, not through direct action sometimes, but sometimes through inaction. So if a parent is simply not feeding the child, maybe it's a 2-year-old, they need constant attention, feeding, diaper changing, so be it. Though there are a lot of proactive actions that are required of the parent. If those things are not taken, are not being done, then whether it's if the parent is unable to do it or if they're unwilling to care for the child, and they haven't arranged for an alternative person to take care of the child, another caregiver, maybe it's a stay-at-home nanny that's going to help the parent take care of the child. Those are things that could have avoided a finding of neglect. But if the child is neglected, that's one of the ways that the legislation or the law says that this child needs protection. CAS, you need to go and see whether or not you need to protect them, since they are not protected at home. The second way is if the child has been abused, or again, maybe they haven't been abused yet, but they're likely to be abused. And here we're talking about all forms of abuse: physical, sexual, emotional. And then even extends to whether or not the violence is directed towards the child. So if the child merely sees abuse or violence between 2 adults, perhaps 2 siblings or 2 parents, in the home, that's also another trigger to say that the child is in need of protection. Just a point in mind again is that it's all about the child. It's not about the parent. So it doesn't matter which parent is abusing the child. If one parent knew about the abuse or should have known about it and did not try to stop it, the CAS can investigate. Just because one parent isn't the one to actively abuse the child, if they knew of it, then they should have tried to stop it. So how did the Children's Aid Society, the CAS, hear that your child may be unsafe? So there's two ways. One is that anybody could have told the CAS that a child is been harmed or might be harmed. That might be your relatives, your friends, your neighbors. Anybody can just go up to the Children's Aid Society and report. Your lawyer cannot, though. That's the one exception to the rule. And then there are some professionals which work with children who must tell the Children's Aid Society if they believe that this child is being harmed. So these professions are usually those that work with children. So they're the teachers, they're the doctors, nurses. They're the ones that see the children for a long period of time when the parents are not typically there. They're typically like your daycare workers, counselors, social workers, and clergy. A lot of these types of professions, if they don't tell the CAS, then they can be criminally liable and face personal consequences. Again, one of the professions that definitely does not fall under this category is your lawyer. You have utmost confidentiality with your lawyer, and your lawyer is not obligated to tell the CAS the details of the situation. Obviously, because they are there to advocate for you. There are, of course, certain scenarios which are very extreme, which can put a child at severe risk that can trigger a lawyer to seek different ways. But essentially, your lawyer is not allowed to inform the CAS that this child is in need of protection. So with respect to domestic violence and the Children's Aid Society, if you are being abused and the police are called, Children's Aid Society may come to your house alongside police. And this is because it's concerned, the Children's Aid Society may be concerned that the abuse happening to the adult is actually affecting the child's safety and well-being. So it's possible that a woman seeking help from the police may feel like she's being investigated by the Children's Aid Society, right? And this might feel pretty uncomfortable, where you're there seeking help from police, and then all of a sudden your child is now removed from you, even though you did nothing wrong and you're just the victim, right? So, but it's not that, it's not to that extent. It's not that they will remove children just at any site of violence. It's really that if you're not doing what you should to protect your child from harm, that they may remove your child. Because again, it is what is in the best interest for them. It's not about your right to have your children. Just some general tips with interacting with Children's Aid Society, some things you should know. So Children's Aid Society almost always have to get permission to enter your home. So they will knock on your door and ask to enter your home. They can enter by force, that's kind of rare, only if they really need to protect a child who's in there and it's an emergency. But other than that, it's out of consent that you permit them to enter your home. So if you have difficulty speaking or understanding English, please ask for an interpreter and don't use your child as an interpreter. Very frequently, this is a habit of a lot of people who are not native English speakers, where they will rely on their children as interpreters. That may work in other contexts. Obviously, when you're dealing with Children's Aid Societies and you're going to be talking about sensitive issues, potentially about the child themselves, it's not going to be a very fruitful or productive experience for that child to interpret language that is being discussed of this type of vulnerability. So please try and, you can ask the Children's Aid Society itself to provide an interpreter. You can try and find an interpreter yourself. So answer questions carefully, and that's because the Children's Aid Society, they keep notes on everything you tell them, everything the children tells them. And this is all information that, of course, informs their decision as to whether or not they feel they may need to remove your child from your care. And of course, in order to justify such decisions, they may bring that information up in court. And so this is information that is really critical. At the same time, though, you should know that unlike in criminal matters where you actually have a constitutional right to stay silent, you know, we see that in the movies where as soon as somebody's being arrested, people tell them, you know, anything you say can be used against you. You can get a lawyer and you have a right to stay silent. You actually don't really have that. There is no constitutional right in when the Children's Aid Society is speaking with you. And on the contrary, if you do stay silent, there can be a negative inference where the Children's Aid Society can say that you're being uncooperative. However, you don't have to do everything and anything the Children's Aid Society says or requests of you in order to be cooperative. It's really just making sure that you are engaging with them in a professional manner and communicating with them respectfully. Of course, if the if the CAS worker arrives with police, that's a hint towards you that you are not only being investigated for, or your child's circumstances are not only being investigated with respect to whether the child is in need of protection, but you yourself are also being investigated with respect to any criminal charges, because certain actions can also lead to your criminal liability, right? If you abuse your child, it's not only the CAS that is now going to fear for the child, but the police may charge you for the abuse that you're doing towards the child. So at that point, if you feel at any point that you are being suspected of a crime, you should definitely refuse to answer any questions at that point. You stay silent. You say, I want to get a lawyer before I answer any questions. So if the CAS worker does arrive with police, then you definitely know that you're going to want to get a lawyer first. And if they arrive without police, usually when the CAS is coming to you, you will know whether or not you are being investigated for a crime because you have done something wrong, or if your children are being, or if the CAS are gathering information to protect your children. So what can the CAS do? So after investigating, if the CAS decides that the child does need protection, the CAS can do two things. It can ask you to sign an agreement to work with the CAS. So this might mean that you consent to the release of some records. And that means that they are still actually investigating a little bit more, right? They might want some medical records to see, to be able to identify if you have maybe bruised your child or hit them in a specific way. There are also agreements, such as care agreements, that outline certain ways you're going to take care of your child, right? So that might mean that you are agreeing to attend a certain type of family counseling sessions. Whenever you want to sign an agreement to work with the Children's Aid Society, you definitely should talk to a lawyer before you sign any documents. That's because you are always exchanging rights, right? You're giving something up and you're taking something. You definitely want to make sure that you fully understand what it is that you're signing, because that's typically where parents will get very frustrated in their work with CAS, is that 5 years down the road, they don't understand what it is that they signed to, and that really leads to a lot of frustration down the road. The second thing that a CAS can do is remove your child from your care, right? So if they don't think that it's going to work out through an agreement of a care agreement of any sort, and it seems like your child is really in need of dire protection, they can relocate your child from your care and place them with a family or member or a community member or in foster care. And so at this point, the age triggers in. So if your child is 16 or 17, the CAS can only remove your child from your care if the child agrees. So if they are less than 16 years old, the court must consider their views, as long as they can articulate how they feel and express themselves. But this doesn't mean that the court has to just listen to whatever the child wants to happen, right? But as soon as they are above 16, now there's a requirement that the child must explicitly agree that they want to be removed from the care of their parent and placed either with a family member, community member, or in foster care. So if a Children's Aid Society does remove your child, what are the steps that you should do? The first thing is that you should try and choose your preferred caregiver. If you have that luxury, if you know of a family member or an adult from your community that can take care of your child. A lot of Children's Aid Societies actually have types of arrangements with local mosques. They'll do email blasts to say, so-and-so is of our community. So if there's anybody from our religious community that is capable of taking care of a child, please volunteer. And that's because it is something that is prioritized, is when they are trying to identify what community setting or foster care setting to be placed in. It is a consideration that the Children's Aid Societies typically will try and place them in essentially a foster care that does match their background. And the second thing would be to seek legal advice right away. This is because child protection hearings happen very, very fast. So even within 5 days of your child being removed from your care, you will have a hearing. And so the lawyers are going to need some time to fully understand the facts of your case. So you don't want to wait on that. And you should definitely seek legal help, even if your child is taken not to a foster care, but to your own relatives, even if it's your own family member that your child is going to, maybe it's your own mother. So the child is with their grandparents. You should definitely still seek the legal advice because things can change. And the third thing is to get access to your removed child. So you or the person who was taking care of the child right before they were taken away, usually have the right to see your child before the hearing or the trial. And that's because it's usually, again, in the best interest of the child to continue seeing the caregiver while the court decides the child protection case. So just some more information about the importance of seeking legal advice. As I said, these child protection hearings happen very quickly. They are very complicated. You need a lawyer who practices in child protection, not just any family lawyer practices this. And they have very strict timelines because they don't want the child to just be waiting while people are fighting their legal battle, right? Every day counts when this child is not with their parent. So if they're less than 6 years old, the maximum time that they're allowed to be in a temporary arrangement for is only 12 months, so 1 year. And if they are 6 or greater than 6, that maximum time is now 24 months, so 2 years. And when that time limit is reached, the court has to return the child to the parent, community, or family member, or else they have to have the child adopted, because they're not just going to keep having the child bounce around in temporary arrangements without a final determination, because it's not in the best interest of the child to do so. So like I said, seek legal advice as early as you can. So where you can find legal advice, the Law Society Referral Service, it's an online service that gives you the name of a lawyer in your area who can give you a free consultation of up to 30 minutes. And you can actually ask for a lawyer who speaks your language and one who accepts legal aid certificates. Legal aid certificates are essentially a certificate that you can get if you have a low income and if you're eligible for it. And that's a way to reimburse the time of a lawyer who would otherwise not be able to take on your case. So they would be getting funded and reimbursed not through you, but through the legal aid certificate. And the Legal Aid Ontario, LAO, I put the link in the PDF PowerPoint, which you will get. And it's essentially has a lot of different services that help people with low income get legal assistance. So this can be certain types of advice and certain types of representation in court as well. And so definitely recommend to see if you're eligible. It's based on income as well. So the third thing that I mentioned to do when and if your child is removed from your care is to seek access. So here, when we're talking about access, we're not talking about the same type of access that we were talking about at separation or divorce, which is no longer called access anyway, so that's good. Here we're talking about accessing your child with the Children's Aid Society, where you're just trying to maintain a relationship with your child. It's really important that you do this because it lets your child, of course, know that they're important to you. And it lets the Children's Aid Society and the court also know that you care for your child and you don't want them to be taken from you, and you want to stay in touch with them. So how do you do this? Ask for the Children's Aid, ask the CAS worker when they are taking away your child. You ask for it right then and there. You say, I want to be able to see my child and visit them. If you forget to do that, if you're unable to do that, you can always just call them up later and make that request. Irrespective of whether or not the Children's Aid Society does give you access, you should also ask the court to make what is called an access order. And that just means that it is a piece of paper that is signed by the judge saying that you have rights to access your child. And so you can do this in person at your first court date. Like I said, that would be within 5 days of the removal of your child, or in writing, right? So you can actually make a written request for this. So the importance of an access order is that it solidifies your access rights a little bit more. So if you were just to ask the Children's Aid Society worker for this, they would be more capable or more easily capable of reducing or stopping your visits. But if you get an access order, in order for the Children's Aid Society to change their mind about whether or not you can access the child, they're going to have to go to court. So for example, if you miss a lot of your visits and you have an access order, the Children's Aid Society will have to go to court and convince the court that you no longer should be entitled to access your child because you have been missing your scheduled visits. There are different reasons that a Children's Aid Society might want to stop your or reduce your visits with your child. It might also be because you're harming your child on a visit. So of course it's really important to ensure that you are making the best and most use of your time with your child when you are there. So there are certain ways that you can actually complain about a Children's Aid Society, because because a lot of people typically have negative experiences, right? It is a stressful time and it can bring the worst out of people. So there is a procedure through the Child and Family Services Review Board, and they can actually review certain CAS decisions, placements, and complaints related to the services that they provide. So if you have sought or received services from Children's Aid Society and you have concerns about these services, you have a right to complain. If the CAS, for example, did not give you a chance to be heard when you raised your concerns, or when those decisions affected your interests, or they did not give you reasons for its decisions that affect your interests, or they refused to proceed with your complaints. So you might internally complain to CAS before you try and complain to this board. And that's where the last two bullet points kick in, is that if the CAS didn't follow its own complaint review process or timelines, because a lot of CAS agencies, they'll actually have their own internal review processes. So if they are not complying with those, then this is essentially a backup or checkpoint. So as always, I included some resources at the end, and that concludes the information that I have to share with you all.
Thank you so much, Lina. We have one question on the chat. Can CAS get warrants to enter telewarrants?
To be honest, I'm not sure about that one. I would imagine that they could, but I don't know, to be honest.
Thank you.
If a parent did not see his child, does it affect like any timeline of seeing his child in the future, like that?
I'm sorry?
Yeah, like for any instances of one parent cannot see or able to see due to some circumstances or any of the circumstances around like the criminal side of issues, and he cannot able to see his daughter, but after everything gets resolved. But the timeline is like 15 or 16 months time frame. And now, after everything has been sorted out, he wants to see his child. Would that be an obligation that long period he wouldn't able to see his children for a long period? The time has now he cannot able to see. But
I'm really sorry, but I'm having a hard time hearing and understanding the question. Perhaps you can write it out.
Can you hear me now?
Yeah, but it comes in and out.
Okay. Give me a moment.
I'm sorry about that.
Yeah, if you write on the chat, I will ask your question as well. We have one more question about legal aid. To qualify for legal aid, do you need to be a permanent resident, citizen, or anyone who is legally staying in Canada can apply for legal aid?
I would try the link and see. I believe it is for residents, but I'm not sure about that one. Sorry, but it's if you click on the link that is included, it would give you all of the requirements and eligibility.
Yeah. We have a question from earlier. If there is a domestic abuse involved and the husband has temper issue, what happens if the mother called CAS? She doesn't want to go for divorce, but would like to have a documentation in the event of divorce.
So I guess my question would be, why call CAS and not the police? If a woman is ever being a victim of domestic violence, she should be calling the police. That is her first and primary resource to go to. It is a crime for a husband to be harming the woman. And typically, like I said before, sometimes CAS will accompany the police, sometimes without even requesting it. So that would be the typical route to go. That would be my answer.
Yeah. I don't know if you have like information or advice on that, but like a similar case, if there is an abuse, just like the question before. Sometimes if it's not a physical abuse, the police is not like doing much. The only thing happens is like the family and children service are there, and maybe by the end of the situation they will take the kids away if the father is not, or the person who's causing the harm, like could be like verbal abuse or temper or stuff like that, is not cooperating. So family and children service will be taking away the kids. That's why I think most of the time most of the time it's moms under the abuse prefer not to call the police or not to contact the family and children services. But again, it's very hard to decide in this situation. You don't want to take your kids away. Sorry about that.
Right.
Yeah.
It is a difficult and almost awkward situation where you feel like you're asking for help and then you're being harmed more, right? But if you recognize that what they're doing is really in the best interest of the children, and that's basically the idea for it, it's that kind of helps you understand where they're coming from. But it's definitely it feels like a flaw in the system, to be completely honest with you, where somebody who's really facing a victim or being facing this type of violence is then going to feel really scared to reach out for help. But it's basically everybody's trying to do their job, and one of the important jobs that has to be done is making sure that the child is protected, and protected from not only violence that's directly towards them, but also observing and being in an atmosphere of constant violence is definitely something that is makes them in need of protection.
Thank you so much, Lina. Another question is, if a father couldn't able to see or stopping to see his child for a long period of time due to false criminal charges, but after a time when all criminal issues are resolved from the court, but a long time has passed for seeing children for a father, will that impact access to child?
I'm sorry, can you repeat it one more time?
Yeah, I can also send it to you as well. If a father couldn't be able to see or stopping to see if his child for a long period of time due to false criminal charges, but after a time when all criminal issues are resolved from the court, but a long time has passed for seeing children for a father, will that impact access to child?
Yeah, so it will impact, like we were saying earlier, that the length of time in which a child may be removed or not seeing or interacting with one parent can definitely impact their reunification that could potentially happen after the allegations are cleared up and after everybody knows that that was false about the husband or whatnot. So because again, the question is always what is best for the child. It's not about was the dad or the mom right. The judge doesn't care if the mom was right or if the mom lied or cheated or if the husband lied or cheated, as much as they care about where is the child going to be healthy, safe, happy, and emotionally nurtured. So it's really it does affect the the arrangements that are made later on when the child is not seeing that parent for a period of time.
Next question is, do you have any tips on how rationalized people can feel safer, more comfortable interacting with the police when often dealing with a lot of stigma and prejudice?
Mm-hmm. Yeah, so this is a good question. I feel like this is a question that is really based on local municipalities, because the police culture is one of that's really influenced by local municipalities. As you may or may not know, police in general, they are a municipal entity. So every single city has their own police, in addition to, of course, the provincial OPP. However, some municipalities are really good at this, and they're trying to become more progressive with this, where they're trying to hire their own racialized people to create that feeling of safety. Some cities try to have different types of events and collaborations between racialized people and police forces. So I feel like there's a lot of initiatives going on, but with respect to tips for people who are reaching out to police, that's a heavy loaded question, because that shouldn't be your responsibility to begin with, right? It should be the responsibility of the others, the police, to make you feel more comfortable. But I would generally say to not be scared, because I know that's easier said than done, but a lot of police are good people, and a lot of them are, and knowing that, you know, if you are expressing your concerns, that hopefully they can be taken into consideration the right way.
Can I just add to that? Maybe Buju, Holly George, Social Development Center. Happy to be here. We actually had a meeting with the Waterloo Regional Police today about some of the issues that we see in the racialized community and the Indigenous community. And we're actually talking to the community engagement unit, and some of the powerful women, some of the powerful women there at the coalition were there. Sarah and starts with an M, and I'm so sorry. Marie?
Mifra.
Okay, Mifra. I'm so sorry.
No worries.
Was also at that table. So we are talking at a very from the grassroots organizations are talking at these upper level tables with the police about Islamophobia, xenophobia, homophobia, transphobia. So we've just started those conversations today, actually. So things are happening. I just want to let you know. Miigwech.
Thanks, Holly.
Yeah, I just wanted to add to that, Holly. We had other meetings as well before town halls, always with the police, in contact with them, trying to be advocating for some cases that reach us, and we talk. But just one of my tips answering that questions is educate yourself about your rights. Educate yourself as much as you can. When you hear about other story, ask yourself, like, what if you are in that situation? What would you do? So first of all, you need to know the name, number, the badge number of the police officer who comes to your office. Ask them, they're going to give you their cards or something written there with their name. So you can follow up and say that this police with his name came to my place. You need to have something written about the situation. If there's any case of, like, of course my specialty is within the domestic violence and stuff like that, but in any situation, if there is a police involved, have something written about or a number for that report that the policeman has written there. Also, ask, if you don't speak good English, you have the rights to ask for a translator, interpretation. They can wait until the interpreter comes. There is a online, like over the phone interpretation. You can ask for someone to come and use, tell them that you don't understand what they're saying. There's a lot of rights. If you don't know about those rights, you won't ask for them. So you always try to be prepared and learn about your rights and learn about the rules and law as well. So if you know about the rules, you will know what's wrong, what's right, what they're talking about as well. So this is my tip. At least when you have some knowledge, you know what to do. This is my tip around any kind of a situation where there's a police or any enforced law involved. Yeah.
Thank you, Wissam. I guess this question is for you. Are they allowed to refuse to tell you? I believe when you ask the police officer their card and their name, are they allowed to refuse to tell you? That's what I understand from the question. Yeah, their name and badge number. Is police officers are allowed to refuse to tell us?
Their names and badge number, it's there. It's in their jackets. It's written there, and they don't have any rights to refuse because they are a service provider by the end of the day. Yeah, there is representing the law. There's nothing there to hide.
Yeah. Thank you. It's definitely our right.
Yeah. One last thing, if you feel that this police officer or is doing something racist or there is something that doesn't feel right about it, you have the rights to report them. There's a website where just Google reporting police officer or something. There is a website. There is an agency that can review that thing and respond to you. It might take time, but reporting is very important. And at the Coalition of Muslim Women, we have also a reporting line where if there is any kind of racism, any kind of hate toward you, you can report that. You can review our website, the Coalition of Muslim Women.
Just a quick follow-up. I don't know if everybody read it or understands what I'm talking about in the chat. So from my meeting today, the Waterloo Regional Police has a dashboard available where you can see all of the officers who are presently on duty and which languages they speak so that you can actually, or whomever can actually see, and you can request that officer. Just, that's a practical tip. Miigwech.
So if there's no more questions, we can come to an end of this session. Of course, feel free to send your questions even afterward. I will be sending all the recording from the previous session and this one and all the presentation early next week to everyone who participated in any of the sessions. Sorry for the delay from before, but we wanted to have them all together, so it's in one package. And I think it's coming to an end. Thank you so much, Lina, for all the information and for your time. And we also want to thank the Muslim Legal Support Center for the cooperation and providing this kind of sessions. As I mentioned, we're going to be providing the same set of sessions in Urdu, which is already started, and in Arabic and in Somali. So please, if you have anyone is interested to join our session, refer them to me, and the email, you can find it in the chat. Thank you so much. Thank you, Lina. Have a good evening. Assalamu alaikum.
Assalamu alaikum.